in cases where assistant commissioner passed an order, commissioner has passed an order, commissioner has passed the order, and your application is pending for stay, whether they can affect a recovery. Circular was issued by the CBEC last year, saying that it will affect a recovery. Then the Bombay High Court struck it down. Okay. I told Justice Chandraju, sir, last year CBDT gave this gift to the industry, this year this gift is a CBEC gift. Because in 2012, CBDT came out with a circular, which was struck down in the UTI case. UTI case was judgment of the Bombay High Court on recovery pending the stay applications. UTI case. That was a direct. Then I told him, this is CBC. This. Then, after the judgment was delivered, the department was feeling that judgment is applicable only for LIT, not for all associates. Then I mentioned to the court, sir, they are misusing your kindness. Then he passed a judgment saying that highest administrative authority in Bombay, Maharashtra, is directed issuing administrative guidelines, bringing to the notice of the authorities concerned that this is the law laid down by this court. I don't know if the Chief Commissioner issued a circular of that kind. If not, Chamber can ask the Chief Commissioner right now, enclosing ultra tech and the second judgment of the Bombay High Court, making it clear that you cannot conveniently misconstrue it, deliberate and conveniently misconstrue it. Okay. So that will solve at least applications, stay applications pending for commissioner. So because January will remain, that chamber should write that. That is one. The more serious problem is now that 360 days or 365 days, the Tribunal took the view, somewhat casually, that we have the power to extend even after the amendment. And Allahabad High Court has now set aside the Tribunal's order and said no, you cannot extend beyond 365 days. I am now told that the CBC met or something under pressure of the ministry, etc., to fully utilize the amended section. The amended section says that beyond 365 days, no stay can be, even if the assessee is not responsible for the delayed disposal of appeal, stay will stand vacated. So you will have string of cases based on this. One is stay application is pending, that is okay, that is taken care of. Secondly, tribunal extends 6 months, they automatically extend those. But third is beyond 365 days, they are now in the process of, and they will have series of cases in this week itself. Because yesterday I got a call from ONGC saying the attached grant amounts in 365 days are over, tribunal has extended the state to the disposal appeal. Problem is, Allahabad High Court had taken a view that in view of 365 days, tribunal cannot grant stay. Karnataka High Court in some case, in income tax, after the 2008 amendment, also taken the view. You all must be aware of it. I am told Ecom Gill Coffee Trading Company. Ecom Gill Coffee Trading Company. Karnataka High Court took the view that no, after 365 days, even the assessor is not responsible for the non-disposal appeal, state stands with it, recovery can write. And Karnataka High Court declined to follow the Bombay High Court judgment in Narayan's case. Narang overseas, the sequence is, there is a judgment of Justice Regular on David Narang overseas saying, and that was pre-2008 income tax section 254(2)(a), saying that the tribunal does have the power to extend it beyond 6 months. Okay. Then the Bombay High Court followed it in Ronak 2011, 333 ITR 99. Post 2008 also. Why I am referring to this is, somebody should say Narang overseas is 2007 section of 254(2)(a), and 2008 we have made an amendment expressly saying notwithstanding there is no fault of the assessee. So 2011 333 ITR 99 Ronak Bombay High Court follows Narang after 2008 also. Okay. Karnataka High Court has not agreed with this. At least as far as Bombay is concerned, we can insist on this. Second, any cases these are likely to be the spate of dispute next couple of weeks, you all must move the High Court, challenge the section if a problem arises. And say that in your Narang and this thing, this section should be struck down. On point out how the tribunal is not able to dispose of appeal for next 10 years, 15 years, etc. In case we are going everything going this, if the section is struck down or stayed, that will solve the problem.
So can we make a fresh application for the waiver of the pre-deposit?
That's what we are discussing, sir. You may make, but High Court, Allahabad High Court says you have no power. Karnataka High Court said you have no power. Bombay High Court says you have the power. Okay. But there is no purpose in, because tribunal will say we are bound by Allahabad High Court in exile itself. Okay. So you are in for some complicated, pressure days in the next couple of months on because of this issue.
They are not, sir, they are not, sir, extending it. I am saying it's a fresh step.
No, that's what he's
Next 2 days. You know, these 2 days. That's the contention we are raising. But Allahabad said no. Any case, this is the stand revenue has taken and they are implementing it seriously. Okay. So this will happen. So आप जो बोल रहे थे ना stay applicant is pending, वो तो पुरानी बात हो गई. The current problem is this. What's the other one on recovery, sir? The last part on recovery is your bank account attachment, etc. Okay. I am told the practice followed here is get a statement record from assessee that I am liable to pay. If it is a case of collection and not remedy, it's a different matter. That is under 73A. In case they will say they will accept, they will get a statement from the director saying he is liable. He has not paid it. Therefore, the right to the bank. In statement dated so and so, director of the company has accepted, he is liable. Therefore, I request to freeze the account. This matter is under challenge in the High Court. We say there is no question, even if it is admitted. Admission is only a piece of evidence, okay, which can be used during adjudication proceedings. That is not a substitution for adjudication. So the matter is to be argued or the matter will go over in about 2 weeks' time. So, cases where you are not collected but you are admitted during investigation, as of now the writing to the bank and customers, but that problem should get resolved in 2 weeks' time. Either way the court will say they have the power, they can circumvent every provision of law, or they will say not possible. That part is over now. I was told, I had a curious case. One state bank general manager met me, saying, sir, my job is at stake because the service tax fellow wrote to the bank manager attaching the accounts. Even after a letter acknowledging it, you predated and allowed the party to withdraw money from the account or something, and therefore disciplinary action will be taken against him. When you now go to the bank, there is no money. Disciplinary action will be taken against him. Okay, the service tax department wrote to the State Bank of India. So that's also government. Immediately fix responsibility, take necessary action. I then asked him casually, is it an OD account or what? A cash credit account? He said, yes, sir, overdraft account. So, sir, overdraft account. They want to, if the manager continues to allow the assets to operate account in the overdraft account, there is no breach, there is no attachment possible for overdraft account. That the Bombay High Court has taken a view. There is a judgment in sales tax itself, but I am not able to get it in. I'll try and get you that. This is in Sargam Foods, that's the state of Maharashtra. Writ petition number is, it might be reported, I don't know. Writ petition number 4313 of 2008. This is on 8 July 2010. So as far as OD accounts are concerned, there is no problem. But if they write to customers and say they don't make payment to them, to me, then there is a problem. The garnish proceedings. Unlike income tax, where that man says I owe nothing to him, if the state says no such provision is there. And the Mahindra Bank telephoned me. Sir, this is too much, sir. The service tax department writes a letter to me that you are such and such fellow is in arrears. You owe him some money. You please pay that to me. So it first goes to accounts department, etc., etc., etc. By the time it lands in the excise department, service tax department, the company would have already generated money and paid that fellow. What happens, sir? I think you are in trouble. You are in absolute trouble. There is no. After the letter is served on you, your internal coordination, you would have company would have pre-programmed it. All vendor payments will reach on 60th day. So automatically it will be released. So you are in trouble. Plus, may not happen in practice. I am sure service tax department doesn't write back to all the people whom they will garnish notice. Now I receive money equal to the arrears. Okay, you garnish notice withdrawn. Kabhi nahi karte. They write to all customers for same 10 lakhs. There is no record of who was paid, was not paid. There is no garnishing notices themselves do not communicate with each other. It's a mess in the section. The courts have said this should be used sparingly and rarely because of these problems. Okay. Our fellows, even without waiting for an adjudication, resort to this power. Legally, garnish notice issued if that fellow makes a payment to the party instead of service tax department, he is in difficulty. He has to challenge the garnish notice, particularly prior to, because after the order is passed, you will be governed with a stay order. Prior to the order, you have to file a writ and get that order. Okay. Thank you very much, sir.
Sir, only one more question on the Gandhi, sir, if you allow me. Sir, before the due date, can it be applied? For example, I have the credit period of 3 months from the creditors. So now in my book, I have 1 crore to pay to him. I have
to the defaulting assessee.
Yeah.
You are Mahindra and Mahindra. You have to pay 1 lakh to Rajiv.
1 crore rupees.
To Rajiv, who is a tax
I
evador.
pay 1 crore rupees, sir. For 1
Right.
crore rupees. And that 1 crore rupees, as per my terms of the purchase order or a contract, is not due as on date. It is due, suppose after the March 2014.
Yeah.
Is it due only or sir, this simply is lying in my credit? Account of the credit. The Gandhi operates, sir.
Whenever you make payment to him, instead of making payment to him, you pay to him. That's all.
So after it is due date, no sir?
Absolutely.
After it is paid.
That's what I think. I am not saying
Very
yes.
obvious, but you know, they don't understand that.
Anything else, sir? Thank you. Thank you very much.
Thank you, Sridharan, for excellent exposition on the subject.
Friends, I have been allotted the pleasant task of proposing vote of thanks. You know, we, after this voluntary encouragement scheme, we are seeing all these advertisements in the TV and all those things, where the driver is teased by other fellows. Your owner is not paying service tax and all those things. And even the reports in the show many papers where the stern action will be taken against the tax evaders. I think most of us, even myself, we are chartered accountants, we have never seen a person behind bar. So if we see the person that where it is a non-billable and the person is put behind bars on Friday, so Monday bar aayega. Now, with the expertise of Mr. Shridharan and the practical approach he has said to be taken, he has, given the knowledge to us whereby we can, build out our plan in such cases. I therefore request all of you to carry a loud vote of applause. Now, we are immediately starting with the third and last paper on the case study under the service tax, excluding semi-trade and composite ownership by CFO in matter. Thank you very much.